Welcome back and thank you for staying with us. Well, Reeva Steenkamp's killer, Oscar Pistorius, is trying to force Correctional Services' hand to grant him parole. The Blade Runner has asked the court to instruct prison bosses to give him a parole hearing. Pistorius is in prison for killing his model girlfriend on Valentine's Day 9 years ago. Let's bring in Tania Koen, the Steenkamp family lawyer, to give us some reaction to this. Thank you very much, Tania, for your time here on eNCA. Just tell me what the Steenkamp family thought when they heard that Oscar Pistorius is basically now approaching the courts to force the parole board to hear him out on his application for parole.
Well, they've always had the view, and I share their view, that the law should take its course. We all have constitutional rights, and it's any offender or any public citizen's right to approach the court to enforce their rights if they feel they have a right to do so. So they accept that he has a right to approach the court. They don't agree with the fact that he's yet eligible, but they believe that the law must take its course.
And the fact that in his papers to court, in this application, he says that he's already served more than half his sentence, and usually this, gives some prisoners the right to apply for parole or be heard at least in their application for parole. Is that reason enough, do you think?
Obviously, if he has served half his sentence, then yes, he is eligible to be considered for placement on parole. But we don't believe that he has served half of his sentence. And the reason for that is that the Supreme Court of Appeal, there was an amendment which was in January 2021, where the court said that, you will remember, firstly, the court found that he had to 15 years, serve 15 years, and there was no substantial and compelling reasons to deviate from that. So the issue came that took into account the 1 year and 7 months that he had already served. So that's where the confusion arose. So the first amendment, the court decided that they would date it back to 2016, and then a second amendment came out where it said it would be dated back to 2014. And we're saying that the first amendment is the correct amendment, because that would mean that he serves 15 years. So in our view, he's not yet eligible to be considered because he hasn't served half his sentence.
And that's, of course, because of those 500 and something days that, they argued he had already served and should be considered as part of his total sentence. But is the Steenkamp family basically okay with the fact that one day they might see this man free again?
As an attorney, it's my job to prepare them for that. So they have been prepared, and they understand that if he's eligible to be considered, and if the parole board then makes that decision to place him out in parole, they have no choice but to accept that.
And of course, there was also that report that his father had reached out, or his family had reached out to Reeva's parents at some point. How do they feel about him? Do they feel as though they want the reaching out to come from him directly and not necessarily from members of his family? I'm
not sure if you're referring to the victim-offender dialogue where the conversation took place between Oscar and Barry?
Yes, that's correct.
Yes. Obviously, that meeting took place in June, and unfortunately, the information is confidential. What happened there is confidential. Okay. But the meeting did take place, and they did speak about what they wanted to speak. That's unfortunately all I can comment on as far as that is concerned.
All right. Well, thank you so much for speaking to us. Obviously, this is going to be quite interesting in terms of what the court will decide. But just a quick question, Ms. Koen, does that mean that obviously then you as the family lawyer would need to be contacted for the courts to find out how the Steenkamp family feels? Because obviously there's also that victim impact report that the court and even the parole board would have to get, right? So would that be the process if the court decides to hear this case?
So no. What will be heard by the court now is purely on the papers whether Oscar Pistorius is eligible to be considered for placement on parole. So the family will not be involved in that. We are not involved in that. The Department of Correctional Services and the parole board, they will have to respond to that. to the application.
And then at what point would you have to be brought in?
Only once the parole board has considered or has given a date where they will consider his placement on parole. That's when the family will then be invited to either appear in person or whether to make written representations, which the parole board needs to consider when they decide whether to place him on parole.
All right. Well, thank you very much for speaking to us. That is the Steenkamp family lawyer, particularly Reeva Steenkamp, Masego, speaking to us there about Oscar Pistorius approaching the court saying he is eligible for parole and he wants to be heard. All right.